Field Limit 4426 says, "Greetings." Auditum says pronto.
Greetings and welcome to the Demurrer, a historical and legal analysis. This is based on the work of Allison Reppy, New York Law Forum, 1957. That said, remind everyone this is strictly for the educational entertainment purposes of this YouTube channel and broadcast, not to be used, misconstrued, or abused for anything legal, lawful, personal, private, business, tax, financial, or otherwise, so please don't do this at home. That said, let's get started. So as we've been going through pleadings, we've come across the term demurrer. So what is a demurrer? It's a unique common law device. Its purpose is to raise an issue of law, not fact, by assuming all facts are true. So it's a way of logically determining if there is a conclusion of law that could be determined even if the facts were true. Its origin is not Roman, but Germanic. It's the right of refusal to answer. So this is something that's come into the common law outside of the Roman civil procedures. Its function is a procedural weapon for testing the legal relevancy of an allegation before any resort to proof. So before you get to the problem of litigating facts and bringing them into evidence to prove, you look at the whole relevancy of the allegation and you're testing that first. So let's continue here. And make sure you pay attention because we're going to have a quiz at the end here. So the critical distinction with pleading, it denies a consideration. So with pleading, it creates an issue of fact. The question with pleading is, was there a consideration? Was there some type of agreement or expectation or obligation, right? It's an issue of fact. But the demurrer admits all these facts and creates an issue of law. It presents a question, do these facts, as a matter of law, state a cause of action? So it's really testing the logic of the facts and the matter of law they're claiming causes the action to be before the court. So the injustice of ambiguity. This is the problem of secret snares. These are the little traps. Before 1585, a general demurrer, we'll get into the terms here, what general means as opposed to specific. A general demurrer did not need to specify its grounds. This allowed defendants to hide winning arguments and spring them on later, often after a trial had already occurred. The result was injustice, delay, and reverse judgments on technicalities, creating a system of secret snares. So all these little secret technicalities within their little societies there were able to keep a system of secret snares or traps. So the first major reform was in 1585. The goal was to decide cases on the very right and cause of the matter. So big difference here is to decide cases. And this is a statute, I think, of Elizabeth in 1585. The rule is judges must ignore defects in form, those technicalities, unless they are specifically and particularly set down. So the other party would specifically and particularly oppose them or object to them. The effect is we have a general demurrer, which is substantive defects only, and a special demurrer, which is formal, the technicalities plus substantive defects. Either way, substantive defects must be there in a demurrer, but the special demurrer can actually use some of the technicalities within it. We'll get into that in just a moment. Oh, wait a second. Well, okay. Just a second here. Yeah, okay. We're on track here. It's just a different order than I remembered. All right, let's continue here. We're on to cementing the distinction here. Oh yeah, this is 1705. This is the statute, I believe, of Anne. Goal was to reinforce that 1585 statute and stop judges from treating minor defects as substantive. So setting rules for that. The rule now specifically listed defects like omitting viet armis or by force, right? That must be treated as formal. And the result was cemented the distinction and pushed the system toward substantive justice, not looking merely at the technicalities of the pleadings and letting cases be ruled based on those mere technicalities and overlook substantive parts of the case.
Norcal Bishop says, greetings from NorCal.
Welcome, and glad to have you here. We're going to continue on here with defining these terms here. The defects in substance with a general demurrer. It's missing a legal element. So we're using some examples here. This would be a general demurrer, would be that defect in substance. That would be missing a legal element. So this is part of the legal argument. An example given is no title alleged in an ejectment case. So let's look at this more closely. It could also be a defect in form, a special demurrer, stating facts in a way that violates a rule of pleading. So here's looking at it from a special demurrer. That'd be an example given here is alleging a grant deed instead of seized of land. Do you see here the defect? And then there's the speaking demurrer. These are less used. The demurrer that improperly introduces new facts or varies the facts alleged, and that's generally overruled, is out of order. So looking at here, we have the general demurrer, which is missing a legal element, no title alleged in an ejectment case. Ejectment requires to have a title. If there was no title alleged, it's a defect in substance, not just in form. But if you want to say a defect in form, it'd be if instead of just there was no title alleged, they are alleging a grant deed, instead of specifically in law of the seized of land, then that would violate a rule of pleading. So there could also be the special demurrer, and we'll see how this blurs into the pleading aspect of it. Let's continue here. I hope you're paying attention, because now we're on to the general versus special demurrer. What's the difference? So here we're going to break it down. In a general demurrer, what it attacks? The core of the case. In other words, the lawsuit is missing something essential. Even if the story is true, it doesn't add up to a legal claim. And here's an example. A lawsuit to reclaim land that never mentions that the plaintiff actually owns the land. How it works. You just say, this case is legally insufficient. You don't have to list every reason why. Then there's the special demurrer. What it attacks? The way it's written. So this is getting back to the common law elements of the way it's pleaded. In other words, the lawsuit is written incorrectly or breaks a rule of formatting. So specifying the rule. Here's an example. Instead of saying, I own the land, the lawsuit says, I have a grant deed, which is evidence, not the main fact. So we see here how that works as almost an omission of a major aspect of the cause of action. Therefore, having this statement that in the affirmative and the positive, I own the land, is far superior to saying I have a grant deed, because we have to draw a legal conclusion that a grant deed is in fact ownership of land. So you may say it's evidence that could lead to that, but it's not the main fact. How this works: you must point out the exact mistake in your demurrer. So very specific when it comes to a special demurrer. The general demurrer is attacking a core of a case, and you just have to say the case is legally insufficient. You don't have to list every reason why. So here's some strategic considerations. Demurring to plaintiff's declaration. Now, this is interesting to look at it this way. You see the strengths and the weaknesses of the attacks and the defenses with demurrers. So demurring to plaintiff's declaration. A plaintiff makes a declaration. There's the too large rule. The demurrer can be too large. If any count is good, the demurrer fails. So you want to target specific bad counts. Again, this gets to the core. If it's going to a bunch of different counts within the action, and any one of them is good, the demurrer fails, because the demurrer is attacking all of them. It's not selective. It's saying that there's a lack of legal cause here. So then there's the demurring to the defendant's pleas. There's the never too large rule, because it can never be too large when you're trying to demur a defendant's pleas. Because if any plea is good, the demurrer fails. So you need to make sure that all of them are demurred, so to speak. Broader scope for challenging defenses. So you're challenging a defense, you can never be too large. You have to just attack every little bit of it, because if you leave any of it good, then your demurrer fails to try to demur a defendant. So if you are the plaintiff and there's a plea from the defendant against your cause of action, you can demur in a general sense here, but if you do so and it's too large, if you're the plaintiff and you're demurring to defendant's pleas, then it can never be too large, because if any one of them are good, it slips through. However, if it's demurring to the plaintiff's declaration from the defendant's point, it can be too large, because if any count is good, any one you select ends up being good, the whole demurrer fails. So when you're responding to the plaintiff's declaration with a demurrer, then if any one of the parts of the demurrer fails, the whole demurrer fails. And I guess conversely, you'll see here, demurring to the defendant's pleas as a plaintiff in the response from a defendant here, if any plea is good, the demurrer fails. So you can never be too large. You cannot let anything slip through, because if any one goes through, your demurrer fails, and now you're going to have that dealt with at trial, or somewhere in the litigation. Broader scope for challenging defenses. So never too large rule, demurring to defendants. The too large rule is demurring to plaintiffs. Important distinction, important strategic considerations. Once you kind of get the idea there, it makes a lot of sense. Now we're on to the enduring impact. Now let's check over here to chat and make sure we're all caught up. And it seems so, and it seems like the automatic response is working, so I don't have to keep tabs of that. So let's look at the enduring impact of the demurrer. The demurrer evolved from a simple oral right to a complex written tool. The statutes of 1585 and 1705 were pivotal in shifting focus from rigid form to substantive justice. its core function remains to ensure a pleading states a legally sufficient cause of action or defense before the parties are put to the expense of trial. So it's for judicial economy and efficiency. So let's look at a scenario here. Here's scenario 1, denying the facts, creating an issue of fact. Here's the case. Plaintiff A sues defendant B in a special assumpsit, a type of lawsuit for a broken promise. It's contractual. So the plaintiff sues, right, for consideration only, the broken promise here, right? So it's for consideration, the defendant's move. Defendant B files a traverse, a specific denial of one allegation. Okay, no, I get this wrong here. The assumptit is going to consider all these. These are all just parts of the contract, because a special assumpsit, I don't want to have to keep saying that one. It's a type of lawsuit for breach of contract and damages that arise from that. So promise, consideration, performance, yeah, there is breach and damages. So the defendant's move, defendant B files a traverse, which is a specific denial of just one allegation. So B denies only the consideration. That's why that's red. So plaintiff A sues for the special assumpsit for all of these counts, but B only denies the consideration. The result? The pleadings have created a single, clear issue of fact. The only question for the court is, was there actually a bargain, a consideration? The other 4 facts of promise, performance, breach, and damages are automatically admitted because they were not denied. So, you see how that works there. The defendant's move, if he only does one allegation, the consideration, then the others pretty much are still standing. Let's continue here to another scenario. Here's scenario 2, challenging the legal logic, creating an issue of law in the same case. So again, plaintiff A sues defendant B in a special assumpsit with the same 5 allegations: promise, consideration, performance, breach, and damages. The defendant's move. The defendant B files a demurrer. And that demurrer states even if all 5 of these facts are true, they still don't make a valid legal claim. The result? The pleadings have created a single, clear issue of law. The question for the court is, do these facts, taken as true, support a legal lawsuit? The demurrer doesn't deny facts. It accepts them to challenge their legal meaning. So they're still up for the jury, so to speak. However, it's looking at the legal logic, and that's the question. So the demurrer is literally an excuse for not pleading. A sues B for ejectment to reclaim land. A alleges B kicked him out, ouster, but forgets to allege that he owns the land, the title. So B files a demurrer saying, you haven't stated a valid claim because ownership is a required fact. So B is excused from answering the flawed complaint. Let's look at this again. So A sues B for ejectment to reclaim land. So A alleges B kicked him out, ouster, but forgets to allege he owns the land. So A sues B for ejectment to reclaim the land. A alleges that B kicked him out. So A has been kicked out. B is there, but A forgets to allege it. He owns the title. So B files a demurrer saying, well, you haven't stated a valid claim because ownership is a required fact. Now B is excused from answering the flawed complaint. He gets to stay. So the key principle is a demurrer allows defendant to avoid responding to a complaint that fails to state a legally sufficient claim. So you see how this works here. This way the demurrer avoids having to do any kind of litigation, proving of facts, evidentiary hearings, trial, testimony, any of that. and it actually it's an answer to the pleadings and almost a way of finding out if there's even a reason in the logic of law to even proceed with the case based on the facts. That's what this is doing right here. So the key principle, as we see here, a demurrer allows a defendant to avoid responding to a complaint that fails to state a legally sufficient claim. Demurrer is also a shield from default judgment. So look at this. As I said, as an answer, if B did nothing, A would win automatically by default. So again, just to remind us as we can see here, A sues B for ejectment because A alleges B kicked him out. Okay, but if B did nothing, A would win automatically by default. By filing a demurrer, B forces the court to consider the legal question. You see this? In this way, it acts like a regular defense, stopping the clock on a default judgment. So it's a shield from a default judgment because it is a response. It's not a plea or a request for discovery, anything like that. It's a way of forcing the court to consider just the legal question before proceeding. In this way, it acts like a regular defense because in the eye of the procedure, it's stopping the clock on a default judgment. The paradox is the demurrer both excuses the defendant from answering and protects them from losing by default. So, excuses them from directly answering the complaint. Remember, as we learned before in informal logic, then answer when responding to a question directly. It actually has a presupposition of accepting some of the propositions within the question as if they're a fact. And in this way here, you're seeing how the demurrer both excuses the defendant from answering, which also helps prevent the defendant in this case from having to commit to any propositions or presuppositions embedded within the question. And it also protects him from losing by default. So it stops the clock on the default judgment at the same time. So this is the dual use of the demurrer. The excuse function, you don't need to answer, allows defendant to avoid responding to legally insufficient complaint. It focuses on the legal sufficiency rather than factual disputes, which are for the litigation. And it has that shield function. It protects from default. It stops automatic judgment against the defendant, and it forces the court to address legal issues before proceeding. All right, how many people we got here? We got to get on to the question and answer part. Let's see if anyone can pipe up in the chat, answer any of these as I read them through. So for question number 1, how does a demurrer's origin as a refusal to answer define its purpose? 2, why was the distinction between form and substance so important? This one kind of gives away. Number 3, how did the secret snare problem undermine justice? And number 4 is, why were statutes needed to fix the common law's problems? And number 5, why does the too large rule favor plaintiffs over defendants? Remember the too large and the not too large. All right, think of that. Anyone respond? Then we'll get on to the cheat sheet here and the answer. So, how does a demurrer's origin define its purpose? It challenges the legal sufficiency without disputing facts, focusing on whether the complaint states a valid cause of action. And on number 2 is, why was a form versus substance distinction so important? Because it determines which defects matter. Substantive defects, missing legal elements, versus formal defects, improper pleading language. And 3, how did secret snares undermine justice? And that was because defendants could hide winning arguments until after trial, causing injustice through technicalities and delayed judgments, knowing that they just walked them right through a little trap. And 4, Why were statutes needed to fix those common law problems? And the statutes were needed to force disclosure of demurrer grounds and prevent abuse of technicalities that undermined substantive justice. So you see how these statutes, we're talking about from 1585 and 1704. Why does the too large rule favor plaintiffs? Because plaintiffs can avoid dismissal if any count is valid, while defendants must address every potential weakness in their plea. So the defendants have never too large, whereas for the plaintiffs can avoid dismissal if any count is valid. So there it is.
Built in 4426 says, I might have earned partial credit, but I was not bold enough to answer.
Don't worry, these are all pretty difficult questions. That's why I had the cheat sheet here at the end. But this gives you an idea of the distinction between just simple pleas and demurrers. And I know we are getting into this now within the series I'm doing on pleading. And as we go through that, you're going to hear more and more in the demurrer, in the distinction. And having this background both in historically and modern with the statutes and such that apply now, you get a better feeling of the way the back and forth goes with the courts, and the reason this is something that actually is good for judicial economy and fairness and full disclosure, which we all know is what really allows a transparency and justice in the fair and equal application of law. Well, with that said, I'd like to thank everyone for coming, and I hope you learned a little bit of something here. I know I did in doing this deeper analysis here and digging up some of the history. And this came from work from Allison Reppy from the New York Law Forum in 1957. So, of course, these things have changed over time, but having that historical context.
4426 says, any difference between this and a motion to dismiss?
Indeed, this is depending on the jurisdiction now, from what I understand, is sometimes these are treated as a motion to dismiss. However, as the record would be, if it is stated as a demurrer, remember, it's regardless of what they call it a motion to dismiss, it's the substance of the wording and the filing itself that determines its nature, not just its title. So it may be sometimes entitled motion to dismiss, which would still be a demurrer in some cases, from what I understand. But again, the content is what rules as far as the nature of the document, not the title. And if any other questions, we can let me know right now. Other than that, we're going to move along here. Just to remind everyone that I did open up the members-only live stream membership level here that our generous corporate sponsors, YouTube was suggesting some content creators to get more engagement from the audience by allowing us to extend live streams into members-only ones where we could have open panels and some discussion between different members. And I left that at the low level they had there just to see if they were going to get any kind of interest in it. If we do, I'll set up the panels, and I'll probably set up shorter live streams here so that they won't be too lengthy when we go to transition over to the members-only portion with the panels. And I'll provide links for all that too at that transition. With that said, I'd like to thank everyone for being here, and I hope to see you all on the next one. Peace out.
The tribe says, hit the like. Bill Famous 4426 says, take care all.